lobbying for funds to contest as the president of this country, let me hope I am not supposed to register, because it is our policy to promote democracy.
Yes, but Clause 2.2 has told you, in the promotion of your democracy, you should get the promotion of the democracy. Yes, you can get some support from outside, but much of the support should come from Uganda. So, promote democracy.
This time I'll help the Attorney General. Actually, the answer lies in 2.2a. If what you're going to promote is engaging in political activities in Uganda, or in the interest of a foreigner, you go to General Tafiri for permission.
Yes.
A quick one, Honorable Chair. Actually, in line to what Honorable Zijan stated, I wanted the Attorney General to be clear. Faith-based organization. I remember when we were making the NGO amendment, we were very clear. Where does it leave the faith-based organizations?
Thank you, Honorable Keyo. That's
are
exactly
they catered for? Are they not covered in the law?
So,
and that's
we'll leave that to the committee. If you think it is okay for faith-based organizations to participate in politics in the interest of foreigners, the committee has the power to allow them. Because you see, this act is talking about specific activities which are not for faith-based organizations. But if the committee thinks that is perfectly fine for a faith-based organization to participate in politics in the interest of a foreigner, we can exempt them. No, what I'm saying is that these faith-based organizations are already exempt from this law because for them they don't participate in politics. They don't solicit money for the benefit of the foreigners. If they do, well, what we are saying here is, for me, the faith-based organization that I know doesn't do it. So, pardon?
I'm asking whether, I think now you've clarified that this is purely political.
It is political, social.
If the faith-based organizations are going to solicit for funds in the interest of foreigners, then they can. If the politicians are, then they cannot. Is that
no,
what you're saying?
What we are telling you is that the law as it is written now, even faith-based organizations should not solicit for funds for purposes of supporting a foreign policy here. But I'm saying, if the committee thinks that it is prudent to exclude the faith-based organizations, then they may be able to do so. But for us, the way we've written it, we have said, no, if it is a foreign interest, none of us Ugandans should participate in it. Whether faith-based company, whatever, don't do it. The money come in, and then deal with it after. But that I leave to you. That's what we thought. We thought it was not wise. We thought it was important to curtail. But what I need to tell you is that this law is not replacing other laws. This law is creating a category of persons to be addressed under this law. For me, what you want to do, I don't know how far more you would put the application of the law. Maybe we should put another clause 3. A clause 4 and say, for further avoidance of doubt. Because we have put for avoidance of doubt.
For further avoidance.
For further avoidance of doubt. And additional avoidance of doubt. The people who are not agents of foreigners will not be required to go to the minister. So.
And you know why there is doubt to be avoided? It's because you cannot be trusted.
Okay, I think we are making headway.
Well, at least
I'll give you a chance, Honorable.
My appointing authority was trusted enough to be elected. So,
okay, Honorable Fox.
Honorable Chair, I want to invite the Attorney General to look at clause 28. 28 2A to C. This is in reference to Segona's defenses.
No wingile, a person who.
The drafting here seemed to have captured some defenses. So can you replicate this when you are dealing with all the other clauses that create crimes?
We are happy to receive the thing. We thought they were clear, but if they are not clear, we'll be happy to to look at the proposals of the committee on how to make it clear.
You have to make it clearer.
Yeah.
Yes, Honorable Anya is saying the law is targeting very few people. Of course, the 50 million Ugandans are not all criminals. For example, we have the law on murder. It's not targeting all the 50,
Including Golanya himself.
Yeah.
He's
It is-
not.
For now, like for you, we are not targeting you. But if you happen to do these things, but you see, the law is supposed to deal with a particular problem. And the problem is not for everyone. So not all Ugandans do this. And actually, the law also may deter others from doing it. So yes, it is targeting a few people.
Of what we want to achieve. The aspect of the checks before the fact, which the Attorney General alluded to, not after, when things have gone bad. But also the bigger worry of the committee was, what if the minister abuses his power? So what better way, if not the minister? I think that we should leave to the committee. If you think the minister is overweight with this responsibility, which is going to be frequent, then what better way can it be addressed?
Politicians, businessmen, civil society, or religious or faith-based organizations are allowed to get money from out, provided that money that they get from out is used to implement the policies of government or is not used to contravene government policy. If you bring in money for purposes of overthrowing government, if you bring in money for purposes of shifting or altering government policy, that is what is prohibited. Otherwise, Ugandans who work from abroad and bring in money, there is no problem to that. Otherwise, people who send money to help their relatives, to pay education, to help the indigent, to support the orphans and the widows, that is not criminalized.
The only worry is that maybe this bill may promote corruption. Why? Last time when we were in the caucus, they tried to take us through the 10-fold development strategy.
10-fold growth strategy.
Yes. And while these people were in Chankwanzi, they added on another 11th point to prevent corruption. But with the bill, I see they have given so many powers to the minister and the department. I think in the line, there will be very many officials. Somebody is going to declare their money that they are getting. Of course, due to the many bureaucracies that is involved, the channel that the money is supposed to go through, somebody is supposed to get a certificate, and we know that the tendencies that have been happening. Somebody will ask for, like, Choja Middle, maybe I need to go and see the minister, I need to go and do. They'll keep on putting up excuses.
Presentation,
Yeah.
then I can support him.
Honorable Minister and the sponsor of the bill.
Thank you, Honorable AG. The joint chairpersons and honorable members of both the Legal and Parliamentary Affairs Committee and the Defense and Internal Affairs Committees of Parliament, the Protection of Sovereignty Bill 2026, Bill number 13 of 2026, seeks to provide for the protection of sovereignty of the people of Uganda, to designate the department responsible for peace and security as the responsible entity for the registration and regulation of agents of foreigners, to provide for the protection of the sovereignty of Uganda, to provide for the registration of agents of foreigners, to regulate the funding and any other assistance to agents of foreigners and for related matters. The Protection of Sovereignty Bill 2026 was read for the first time in Parliament on 14th April 2026 and referred to the two committees in accordance with Rule 135 of the Rules of Procedure of Parliament of Uganda 2025. Background. Uganda's commitment to sovereignty is enshrined in its 1995 Constitution, and Article 1 thereof establishes that all power belongs to the people who shall exercise their sovereignty in accordance with this Constitution. This foundational principle implies that Ugandans, through their government, must be free to make rational decisions and pursue its development agenda without undue external interference. Additionally, the national objectives and directive principles of state policy guide Uganda to promote national interests and resist all forms of oppression. Honorable Chairpersons and members, justification for the proposed Protection of Sovereignty Bill 2026. The bill is grounded in the need to safeguard Uganda's autonomy and stability in the face of specific identified unregulated challenges. The intention of the bill is not an isolationist stand, but a measured assertion of Uganda's right to self-govern and a definition of the terms of its engagement with global systems. The following points outline its rationale and why it is timely and necessary. Filling legal and policy gaps. The technical justification for the bill is that it will fill gaps in the existing legislative framework. While Uganda has laws touching on specific related domains, e.g. the NGO Act 2016, the Data Protection and Privacy Act 2019, the Public Finance Management Act 2015, the laws against money laundering and anti-terrorism financing. These laws address explicit subject matters and do not articulate the overarching principle of sovereignty protection. There is currently no single policy document or legislation that declares and operationalizes the nation's right to insulate itself against external interference across the board. Preserving national security and social stability. Unregulated external funding directly impacts national security, economic and social stability. The government has a duty to protect citizens from destabilization that can be orchestrated or amplified from abroad. Upholding self-determination in policy making. The bill is further justified by the principle that Uganda's policy choices and development path and laws should be determined by Ugandans in line with our country's values and needs. This principle is increasingly important given the instances of external pressure through aid conditionalities as well as unregulated non-budgetary support financial inflows into the country. While Uganda remains committed to international cooperation, it must affirm that core national decisions are not for sale. Similarly, Uganda affirms that any acts intended to impose foreign moral or ideological agendas will be resisted. Strengthening governance and accountability. A sovereign state must also be accountable to its citizens by putting in place regulation on agents of foreigners and foreign funding. The bill actually enhances good governance. It is a move to ensure that all actors on Ugandan soil, whether governmental or non-governmental, domestic or foreign funded, abide by the law and operate transparently. This is in line with the constitutional mandate that all public affairs be conducted with accountability. The justification here is that some entities, especially those with significant foreign inflows, effectively implement quasi-public functions in health, education, human rights, etc., and thus should be held to standards of transparency comparable to public institutions. The bill will require more rigorous reporting of foreign funds, greater disclosure of agendas and beneficiaries, and cooperation with oversight bodies. Protecting cultural integrity and social values. Another justification lies in safeguarding Uganda's social and cultural sovereignty. Ugandans have the right to uphold their own values, traditions, and social norms without undue foreign dictation. Over the years, there have been some instances where external entities have sought to pressure Uganda into adopting social policies at odds with the country's cultural or social beliefs. The bill reinforces the notion that such matters are for Ugandans to decide. This stance is bolstered by international principles of sovereignty. Uganda is a signatory to the 2020 Geneva Consensus Declaration, which affirms national sovereignty in policy decisions. Comparison with other jurisdictions. Apart from the stated gaps within our existing legal frameworks that the bill seeks to address, Uganda also exists within an ecosystem of states and other actors within the international system, with the attendant norms and international practices. Numerous countries across the world, including Western democracies, have similar legislation to regulate foreign influence, foreign funding, foreign agents, and other forms of external interference in their domestic affairs. And we singled out some, and they are there in that table, including the United States, which has the Foreign Agents Registration Act, the FARA of 1938. We have that of Israel, the law of the transparency requirements for parties supported by foreign state entities, 2017. Australia, Foreign Influence Transparency Scheme Act, 2018. Hungary, law on the transparency of organizations receiving support from abroad, 2017-2021. Hungary Steel, Sovereignty Protection Legal Package, Office of the Protection of Sovereignty Framework. France, Law on Compliance with Republican Principles, 2021. In the United Kingdom, Foreign Influence Registration Scheme. The European Union, EU Defense and of Democracy Transparency Framework on Representation of Third Country Interests, and India Foreign Contribution Regulation Act 2010 as amended in 2020 and 2022. These laws, honorable members, are specific to the conditions of each of those countries. Ours will also be tailored to our own conditions and interests. Parts of the bill, 2026. The bill consists of 5 parts and 1 schedule. Preliminary, part 1, this part deals with the interpretation of keywords and phrases used within the context of the bill. Part 2, protection of sovereignty. This part deals with the provisions on sovereignty of persons, functions and services, development of government policy, implementation of government policy, foreign policy, promotion of foreign policy, interfering with electoral processes, interfering with operations of government, and economic sabotage. Part 3 deals with registration of agents of foreigners. This part deals with provisions on registration of agent of foreigner, application of registration as agent of foreigner, consideration of application for registration, certificate of registration, refusal to grant certificate of registration, removal of certificate of registration, suspension and revocation of certificates of registration. Regulating funding of agents of foreigners, that is part 4. This part deals with provisions on declaration of sources of funding, restriction on funding from foreigners, obtaining funds to engage in disruptive activities, foreign funding to government institutions, reporting of foreign funding, and submission of returns. Part 5 is the general part, and it deals with provisions on assistance to the minister, inspection, regulations, and the minister's power to amend the schedule. How the new proposals will differ from or affect the existing framework. The Protection of Sovereignty Bill 2026 introduces a new and dedicated legal regime for the protection of Uganda's sovereignty. At present, Uganda has laws that regulate adjacent areas such as public finance, money laundering, diplomatic relations, data protection, NGO operations, and criminal conduct. But there is no single law that specifically regulates foreign directed influence, registration of agents of foreigners, and foreign funding tied to activities, which, if they are not regulated, may undermine Uganda's sovereignty. The memorandum of the bill expressly states that Uganda currently has no specific law upholding the sovereignty of the country in a manner that addresses these forms of interferences comprehensively. First, the bill introduces a statutory registration framework for agents of foreigners. Under clauses 14 to 20, no person or entity may act as an agent of a foreigner unless they are registered with the department and issued with a certificate by the minister. The bill also provides for application requirements, suitability inquiries, issuance, refusal, renewal, suspension, or revocation of registration. This goes beyond the current framework. Because existing laws may regulate specific areas, but they do not create a specific cross-cutting regime for persons acting on behalf of foreigners in the spectrum of activities covered by this bill. Second, the bill introduces substantive prohibitions aimed at protecting core state functions and sovereign decision-making. Clause 5 to 13 prohibit promoting the interests of a foreigner against the interests of Uganda. Unauthorized performance of functions and services for which government is responsible. Unauthorized development and implementation of government policy, promotion of foreign policy not adopted by cabinet, interference with electoral processes, interference with operations of government, and economic sabotage. These proposals affect the existing framework by creating sovereignty-specific offenses. Third, the bill establishes a special regulatory framework for foreign funding. Clauses 2.1 to 2.6 require declaration of sources of foreign funding, restrict foreign funding above 20,000 currency points within 12 months without written approval of the minister, criminalizes obtaining foreign funding for disruptive activities, requires reporting by supervised institutions, and requires returns by agents of foreigners. This marks a significant change from the current position by creating direct legal control over the receipt, disclosure, and use of foreign funding in specified matters touching on sovereignty. The bill further provides that foreign funding to government institutions or bodies where government has an interest shall be deemed public funds and managed in accordance with the Public Finance Management Act. Fourth, the bill gives the Ministry of Internal Affairs, through the department responsible for peace and security, a clear institutional mandate to implement this framework. Clause 3 and 4 assign the administration and implementation of the Act to the Minister and the department, including review of applications, due diligence, inspections, enforcement of guidelines, and coordination with other government agencies. This affects the current framework by designating responsibility for sovereignty-related regulatory oversight within a designated institution under the Ministry of Internal Affairs. Fifth, the bill will complement rather than replace existing laws. Its cross-reference to the Constitution, the Anti-Money Laundering Act, the Diplomatic Privileges Act, and the Public Finance Management Act, the NGO Act, show that it is intended to operate alongside the current legal framework while filling the sovereignty gap that existing laws do not expressly cover. Likewise, the existing laws operate in silos and do not explicitly articulate or operationalize the overarching principle of sovereignty protection across sectors. In effect, this bill does not merely reinforce compliance obligations, it also introduces a coherent sovereignty protection architecture by establishing a registration mechanism, regulation, approval, disclosure, reporting, enforcement, and offenses under one law. The legal, socio-economic, and diplomatic consequences of the bill as they relate to the Ministry of Internal Affairs' role in safeguarding Uganda's sovereignty. Legal consequences. Legally, the bill will create a clear statutory basis for the Ministry of Internal Affairs to regulate agents of foreigners, oversee foreign funding linked to sovereignty-sensitive activities, and respond to conduct that undermines Uganda's sovereign authority. The ministry, through the designated department, will have express powers and responsibility in relation to registration, due diligence, inspection, enforcement of guidelines, interagency consultation, and advice to the minister. This is important because under the existing framework, the ministry's role in this area is not consolidated in one dedicated legal instrument. The bill will also strengthen legal certainty by defining key terms such as agent of a foreigner, foreigner, disruptive activities, and department, and by setting out offenses, penalties, procedures, and approval requirements. The bill also, in effect, operationalizes constitutional principles on sovereignty and bolsters government functions and cabinet's role in policy formulation and implementation. In that respect, it gives the ministry a firmer legal platform for safeguarding national autonomy and internal stability. Honorable members, at the same time, the bill will require careful implementation through regulations and administrative procedures to ensure consistency with the Constitution, due process, existing licensing regimes, and Uganda's international obligations. The ministry will therefore need to lead the preparation of subsidiary legislation, guidelines, and coordination mechanisms to ensure lawful and fair enforcement of the law once enacted. Social consequences. Socially, the bill is intended to strengthen social cohesion, public order, and national confidence in state institutions. The memorandum to the bill identifies interference in policy and governance processes that a country faces. By regulating these areas, the bill is expected to safeguard the country's values and social fabric against externally sponsored disruption. Within the mandate of the Ministry of Internal Affairs, this means a stronger ability to safeguard internal peace and security by ensuring that activities undertaken in Uganda, especially by agents of foreigners, are transparent, lawful, and aligned with Uganda's national interests. It will also improve accountability in the civic and public space by requiring disclosure, registration, and reporting where foreign interests are involved. At a broader level, the bill will streamline how civil society, foreign-funded entities, and other actors engage with government institutions. The intended social consequence is not to prohibit lawful cooperation, but to ensure that such cooperation takes place in a transparent, accountable, and regulated manner that does not undermine the sovereignty of the people of Uganda. Economic consequences. Economically, the bill will affect both resource governance and regulatory compliance. By requiring declaration of foreign funding, restricting funding above the statutory threshold without approval, and treating foreign funding to government institutions as public funds under the Public Finance Management Act, the bill will strengthen oversight over external financial inflows that may affect public decision-making or support disruptive activities. This will improve transparency, strengthen fiscal discipline, and reduce the risk of parallel financing arrangements that undermine government priorities. For the Ministry of Internal Affairs, the economic consequences are twofold. On the one hand, the ministry will have stronger legal tools to prevent foreign financial influence from undermining national stability and public administration. On the other hand, implementation will require financial resources for staffing, inspection, registration systems, coordination, training, technology, and enforcement. Off-graph members, this has financial implications, and a certificate to that effect was supplied at the first reading of this bill. The implementation over the first 5 years would require additional funding. Cabinet approved that funding need, and it should be available within the medium-term expenditure framework. It also defines administrative, institutional, technology, capacity building, and enforcement costs. The bill may therefore impose compliance obligations on affected persons and institutions, but from the government's perspective, these obligations are justified by the broad and noble objective of protecting national autonomy, ensuring transparent external engagement, and avoiding the economic disruptions that can arise from unregulated foreign influence and funding. Diplomatic consequences. Diplomatically, the bill will signal Uganda's intention to engage the international community on the basis of mutual respect, lawful cooperation, and non-interference. Clause 9 of the bill expressly states that Uganda's foreign policy shall be based on promotion of the national interest, respect for international law and treaty obligations, peaceful coexistence and non-alignment, peaceful settlement of disputes, and opposition to domination and oppression. The bill, therefore, does not reject international engagement. Rather, it establishes the domestic legal boundaries within which such engagement should occur. For government, this means its safeguarding role will extend beyond internal regulation to helping ensure that foreign actors, representatives, and funded entities operate within Uganda's legal and sovereign framework. The ministry will need to work closely with the ministry responsible for foreign affairs and other agencies to distinguish legitimate diplomatic, development, and commercial engagement from conduct that amounts to undue interference. Clause 3 already requires consultation with other agencies, including the ministry responsible for foreign affairs and the ministry that may from time to time be responsible for policy formulation, and all the agencies across government. The diplomatic effect may include closer scrutiny of foreign supported activities in Uganda, but the bill is framed to preserve lawful and mutually respectful cooperation. Therefore, the bill is neither intended as an isolationist measure meant to contract legitimate civic space and activity, but as a lawful assertion of Uganda's right to self-govern and determine the terms of its engagement with the global system. In conclusion, honorable members, this bill differs from the existing legal framework by introducing a dedicated and comprehensive legislation covering registration of agents of foreigners, regulation of foreign funding from foreigners for activities listed under Clause 2.2 of the bill, protection of government policy development and implementation. Therefore, the scope of the bill is to regulate agents of foreigners and foreign funding intended to influence government policy negatively. Since the bill's first reading, we have had lots of conversations.
I left Honorable Segona in his constituency. Honorable chairs and colleagues, I have shared with you a presentation that I have prepared for the committee. I am not going to read, if so pleases you, Mr. Chair. I'm going to highlight the areas in this statement and try to speak to it and try to break it down as best as I could. So, honorable colleagues, the background to this bill has been well set out by the Honorable Minister of Internal Affairs and is really to deal with the management of our sovereignty. Honorable colleagues and honorable members, this is based out of our Objective 4 of the National Objectives and Directive Principles of State Policy, which require that the state and the citizens shall endeavor to build national strength in political, economic, and social spheres to avoid undue dependence on other countries and institutions. Honorable colleagues, Article 1 of the Constitution reaffirms the sovereignty of the people of Uganda, and the sovereignty of the people of Uganda is to ensure that nothing threatens the nation's ability to self-govern without undue external influence. Colleagues, in the absence of the law to protect the nation's ability to self-govern, there has been increase in the interference in our development and implementation of our government policies. Of course, I must emphasize that under our legal and constitutional framework, the policy of government is determined by the government in power at the time, the ruling government at the time. Every citizen has a right to participate in the formulation of that policy, but they are not the policy holders. They share, and then the policy is determined by the government. So this is done through the representatives that we elect, all the way from LC1 all the way to the top. That is how policy is formulated. Otherwise, you can find a situation where each one of us, 41 million Ugandans, may have an idea on how a particular matter, for example, some of us may think that we should drive on the right-hand side, and others think we should drive on the left-hand side. Imagine a country where every citizen decides to engage in their own policy. That would be chaos. So that is brought together by the government now, coming together and engaging with the citizens and coming up with a common policy on that issue. I'm using a simplified, a simplistic example, but it's just to try and drive home why it's extremely important for someone to be responsible for a policy of government. So, honorable colleagues, like the Honorable Minister of Internal Affairs stated, we have several laws that have looked to try and address this issue. But we do not have any particular legislation which has boldly and openly come out to address the issue of protection of sovereignty. And that is what this law is looking to do. Honorable colleagues, Annexure 1 to my brief has got the list of jurisdictions and pieces of legislation that we have consulted. This is not new to Uganda. We have there 17, but if you go out there, you'll find as many as the countries exist on how they deal with the issue of protection of their sovereignty. The issue is, how do we want to do it, and why should we do it that way? And like the Honorable Minister of Internal Affairs said, we need to make a law which works for Uganda. Honorable colleagues, at page 4, I address the justification of the bill, and the justification of the bill is clearly set out in the objectives of the bill. It is to fill the policy gaps, to cover the areas that are not covered by the law, to preserve national security and social stability, to uphold self-determination in policy making, strengthen governance and accountability, and of course protecting the cultural integrity and social values of the people of Uganda. Honorable colleagues, honorable chairs and colleagues, now I go to page 5 and address the scope of the bill, and I want to spend some time on this area because I think this is where our legal part comes in. Honorable chairpersons and members of the Protection for Sovereignty Bill seeks to enact a law that intends to provide the protection of the sovereignty of the people of Uganda by regulating agents of foreigners and funding from foreigners that is intended to influence government policy. Maybe just to emphasize here, everyone will look to influence government policy, and every Ugandan has a right to participate in any process to influence government policy. But if you're influencing government policy in the interest of a foreign player, that is what this law is dealing with. So if you come here to Parliament and you want a policy to be addressed, you want an issue to be looked at, that's perfectly fine. But if you come to Parliament, even as a citizen of Uganda, for purposes of influencing the policy for the benefit of a foreigner, then that's not good, and that's not acceptable, and that's what this bill is looking to protect. In particular, Clause 2 of the bill stipulates the specific areas that the bill will apply to, and I think this is what we need to really address our minds to, because I have heard people talking about people carrying on their legitimate business being affected by the sovereignty bill, people sending money to their parents or parents and children and etc. being affected by the sovereignty bill. That's not the scope of this bill. And I'll go through these items one by one. The scope of the bill deals with engaging in political activities of Uganda for and in the interest of a foreigner. So if you're dealing with political activities in Uganda for the interest of Ugandan, that cannot be the scope of this bill. But if it's for interest of the foreigner, that's the scope of this bill. Soliciting, collecting, disbursing, or dispensing contributions, loans, money, or other things of value for or in the interest of a foreigner. Representing the interest of a foreigner before any agency or official of government, of the government of Uganda. For example, you may come here and say, we should not be, I have a foreign entity which I'm representing here, and its view is that the foreigners who are dealing in business in Uganda should not be required to pay tax. That's perfectly fine. But when you come to government, to the government official, come and tell us you're an agent of a foreigner and you represent the interest of a foreigner, so we listen to you as such. That's what the law is saying. The law is saying you cannot, it is not stopping you from representing the interest of a foreigner, because there may be Ugandans who have interests of foreigners here. We are saying just lawfully do it. Register and say, I am an agent of a foreigner and this is my interest. And not to say that every foreign policy is bad. But if you bring it to Uganda, bring it clearly, stating what your interest is in that policy. Agreeing, consenting, or assuming, or purporting to act as, or who is, or holds himself or herself out to promote the interest of a foreigner against the interests of Uganda. We have our cultural values. If you want to go and promote a foreign value, it's perfectly fine. Just register as a foreigner and an agent of a foreigner and represent that interest. Influencing the development policy of Uganda. For example, in Uganda here, we may say that our development policy now is putting money in the hands of the people through PDM. But you may have a different view. And maybe there is a foreigner out there who does not think it is good for government to give direct grants to the people of Uganda. Because when you give grants to the people of Uganda, maybe they want to borrow money from the bank and etc. And therefore it is your interest to come and promote. So that is the policy of government. The policy of government is under PDM. But if you're coming here to influence that policy negatively or otherwise for the interest of the foreigner, then that law prohibits that. Funding political parties, organizations, or other persons contesting for elections. If you're a foreigner, you have an agent of a foreigner, you want to install into government a government. So you decide to form a political party, you get funding from outside for purposes of protecting the interests of foreigners by, for example, saying, after we have come, we shall amend the law and give all these other people from this country citizenship in Uganda. That's wrong. So you become an agent of those people. And that's what the law is saying. The law is saying just register, come and do it, and feel free to act accordingly. So the scope of the act, as stipulated in clause 2, is exactly how far it goes. It will not apply to funds received by private persons, commercial entities, for family purposes. If I'm receiving money from a foreigner for purposes of doing my business, that has nothing to do with the scope in clause 2. So that cannot be foreign. That cannot be, you cannot become an agent of a foreigner for that. So it can only be in that scope. So the act will only apply to funds that are meant to fund the activities listed in clause 2. That is the activities that are intended to promote the interests of foreigners, influencing the development policy of Uganda, and funding of political activities or contesting for elections for the benefit of foreigners. Of course, the question has been out there. How do we know? That's a question of evidence. For example, when we wrote the law that it shall be criminal to commit murder, we did not tell you how to prove murder. If you stab by the knife, we go and get the evidence, the DNA, in order to prove that you committed that offense. So even if a person received funding from a foreigner and it is meant for these purposes, it is incumbent upon government, if they intend to prosecute that person under this law, to get the evidence to confirm that that person actually brought those funds for that purpose. And if they cannot, then the law will not be held against that person. Honorable Chair and members, concerns have been raised regarding some of the definitions in the bill. It is important to note that the definitions provided for under the bill are only limited to the context of the bill. The word foreigner, for instance, in the bill is used in reference to a foreigner who engages in activities as set out in clause 2 of the bill. That is activities that are intended to promote the interests of foreigners. So further, the inclusion of Ugandan citizens residing outside Uganda in the definition of a foreigner is only limited to instances of where a Ugandan citizen residing outside Uganda is engaged in activities under clause 2 of the bill, and that does not affect their citizenship. Honorable colleagues, maybe just to emphasize this, because it has been a matter of grave concern in the public domain. Of course, the committee will look at it, and we will all look at it, and if there is clarity that needs to be made, we make the clarification. We are saying, for example, if a Ugandan citizen has $100,000 and is in America or in Sweden or in another country outside Uganda, and he decides to spend that money to support his local MP in an election, that's not an action of a foreigner. That's him acting for himself. But if that Ugandan had $100,000 and in concert with foreigners said, let us install a particular MPX for purposes of doing this activity, that person becomes an agent of a foreigner. So even you in Uganda here, if you're in Uganda here and you get money to support an MP, but you get that money for purposes of supporting the interests of a foreigner, you become an agent of a foreigner. So this has nothing to do with citizenship. It has everything to do with the action that you're doing, the purpose for which you're doing that action. And I'm sure the committee will look at it, and if need be, we can correct, clarify, amend, whatever it is, so long as the purpose is not lost. The purpose is, it is not to take away the citizenship of that person, but it is to tell all of us, do not act for the interest of a foreigner. But every Ugandan should be at liberty to participate in the affairs of this country as long as they are acting for their own interest as Ugandans.
Mr. Chairman, with your permission, maybe just in case I lose sight of this, what does the Attorney General and the government lose in simply criminalizing activity without dubbing a Ugandan a foreigner? What do you lose? Because the Baganda sense bambi edibyamutele. What do you lose by simply criminalizing activity without referring to Ugandan as a foreigner? You know, sometimes you cause resentment which is not necessary.
Okay, that's a political way of looking at it. The legal way of looking at it is that the person needs to know that what they are doing is criminal.
Would it be less criminal if you did not use the word foreigner?
No, it will not be less criminal. But for me, my view is, why do I go around in circles? If I want to talk about you, why don't I talk about you? Why should I?
You can actually talk about me without profiling me as a foreigner.
I think that's what the committee...
Actually, what you're talking about
I think that's what the committee can
political,
do.
not legal.
That's what the committee can do. That's what I've suggested. If you think that our view of doing things, then you can correct it. But for us, what we are doing...
That is if I think your view of doing things is political.
If you think, whatever view you may hold, Honorable Segona, I think that is one of the greatest tenets of government today. That even if I do not hold your view in high esteem, I'm entitled to respect it. So I'm not going to say anything about the view you hold, but I've shared with you my view.
The learned Attorney General continue.
Thank you.
We'll ask questions. And besides, that's exactly what we are here for.
I think the Honorable Segona should just be reminded that the Attorney General correctly stated that policies are determined by government in power.
Yes. No,
Actually,
no,
I
no,
don't
no,
need
no.
to be reminded because I have sufficient memory of that.
No, honorable
Simply
folks,
that
we are
there
making
must
laws for
be- no, there
posterity.
must be clarity of policy because as we speak, there is nothing called policy in our law. You just sit, what you decide as cabinet,
Procedure,
bring it
Chair.
as policy.
Procedure, Chair.
Thank you, Chair. In the interest of time and for sanity, may we allow the Attorney General to proceed, conclude his submission. Then we can all weigh in and make our
Own, yeah.
And order. Mr. Chairman,
Order
not right
forward.
to
the
have order
opposite
on
of the word
procedure.
sanity is actually insanity. By the member referring to the proposals as lack of sanity and insinuating insanity, is he in order?
Chair, procedure, you cannot raise order on procedure.
I give a chance to the learned Attorney General to conclude his presentation, then honorable colleagues will come in. Thank you. Go on.
Thank you very much, Honorable Chair. So suffice it to say, the provisions of the Protection of Sovereignty Act shall apply to any person or agent of a foreigner who carries out the activities in Clause 2. The activities in Clause 2 do not include funding for purposes of commercial, private, or domestic use. And like I said, if any of the provisions are not clear, we welcome the committee's advice on how we can make them clear. Now, I would like to highlight on the clauses. Clause 1 is interpretation. Clause 1 provides for the definition of words in the bill, and the words in the bill are subject to the definition for purposes of this act. For example, honorable colleagues, in the Land Act, there is a definition of a foreign company, and that provision says that for purposes of the Land Act, any company which does not have a provision precluding the ownership of the asset of the shares of that company to more than 49% to a foreigner is a foreign company. But we all know that under the Companies Act, that is not the definition of a foreign company. So what I'm saying is that you can define a law for purposes of that law. You provide a definition to suit that particular act or that particular bill. So if that is what we'll say about the definition of foreigner as we had it in this bill. Application, I have stated earlier that Clause 2.2 clearly states the extent of the application of this law. If there is anything that has not been stated in Clause 2.2, it cannot be the subject of this law, because that is the extent of the application of the law. Clause 3 deals with the administration of the Act and places it in the Ministry in charge of internal affairs. Clause 3 also sets out the department responsible for this law. Clause 4 sets out the functions of that department. Clause 5 further re-emphasizes the sovereignty of the people of Uganda as is understood under this law. Clause 6 deals with the exercising of the functions and services for which government is responsible. Clause 7, development of government policy. We are discussing Clause 7 just for clarity, who is responsible for determining government policy and how we achieve it. And also, maybe to also emphasize this, honorable chairs, even when Ugandans want to participate in the development of policy, there is a procedure, a policy, a process that is undertaken. For example, what we are doing here is shaping the policy of government, the policy of the country. Because when government comes up with a policy, it sets the law. And the law is supposed to guide that policy. Parliament comes in to shape it. And we have all this discourse and consultation in order to get that policy right. Foreign policy is defined under Clause 9. Prohibition of promotion of foreign policy. This clause prohibits a person or agent of a foreigner from engaging in any activity, soliciting or receiving or obtaining any assistance from a foreigner to sponsor or organize a meeting or any function with the aim of promoting the foreign policy in Uganda that has not been adopted by a cabinet as a government policy. For example, in Uganda here today we have a government policy that all children should go to school. There are countries that use homeschooling as a policy. For example, if you came to a meeting and you started promoting homeschooling here, that would be against government policy. That's a foreign policy. But for example, you may want to include it in government policy. So you come, discuss with cabinet, discuss with government, and say, let us include a policy on homeschooling. That any student, so for us, our policy is students should go to school. If you have to do homeschooling, there are processes that you go through. So that is the kind of thing that we are saying. I'm just using these examples off the cuff, what may be a foreign policy. Prohibition of interfering with the electoral processes, that is clearly stated. If you get money from a foreigner to interfere with our electoral processes, that is promoting foreign policy. Prohibition of interference with the operations of government. The clause prohibits a person or agent from engaging in any activity, soliciting, obtaining, or receiving any assistance from a foreigner to sponsor or organize a meeting or any function with the aim of interfering with the operations of government. Prohibition of economic sabotage. This clause seeks to prohibit publication of information or participation in any act or activities that weakens or damages economic system or viability of the country, causing economic disruption, insecurity, or instability. Yes, for example, I received only last evening, I received a communication from the National Association of Broadcasters saying that this one will interfere with their ability to run their news. So I think what I glean from the communication from the National Association of Broadcasters is that they are at liberty to say, for example, that Uganda has run out of fuel. For example, when Uganda does have fuel. Or, for example, they are at liberty to say, in Uganda, it is okay to expropriate the property of an investor. So that's what they are saying. So we are saying, no, that's not okay. We are saying that if you're doing it for purposes of supporting the interest of a foreigner, then that is okay. That is not correct. And that's economic sabotage. But if you're doing it as a Ugandan, discussing your economy, and it's not in the interest of a foreigner, then you'll not be caught by the law. So if you're not under clause 2.2, the law doesn't apply to you. Registration of foreign agent. The clause seeks to provide for registration of agents of foreigners by departments responsible for peace and security. And I think this is a very good thing, because for me, if I'm an agent of a foreigner and I come and register and I say I'm an agent of a foreigner, then I commit no offense. I can continue with my business as an agent of a foreigner. But at least then we know. So it provides, clause 15 provides for the application process. Clause 16 deals with the consideration. And clause 17 deals with the certification. Clause 18 deals with the refusal to grant a certificate. Clause 19, renewal of the certificate. Clause 20, suspension of the certificate. And declaration, clause 21, declaration of sources of funding. Clause 22, restriction of funding from foreigners. And this is saying that if you want to get more than 400 million in a 12-month period, just go and apply to the minister and say that I am carrying out some very good work for the foreigners. I have received 400 million for that purpose. I would like to receive some more to carry out the activities of my principal, because I'm an agent of a foreigner. And the minister should be able to give you permission to get more money and carry out the activities for the foreigners. We are just saying that this is perfectly fine. Just say what you want to do. In fact, you can even say that I have a principle to my business is to work honestly to remove the constitutionally elected government for the benefit of the foreigner, and I am registering for that purpose. I need to get 10 billion shillings to do it, and I'm sure the minister, after you meet the requirements, will give you the license and you continue doing what you have to do. Clause 23, obtaining funds to engage in disruptive activities. Clause 24 deals with foreign funding to government institutions, and it's just simply restating what the law says, that if you get money for government, it should be dealt with under the PFMA, and all those are public funds. Reporting of foreign funding and submission of returns. Assistance of ministers, clause 27, and then inspection, and then powers to amend. Honorable colleagues and honorable chairs, and we have received several comments from the public, and our annexure 2 has attempted to deal with these items. Many of them deal with definition, and this is the matter we have been having a great discourse with. I think this is an area that we need to look at together and say, if it is not clear, let's clarify it and give a definition which gives the purpose for which the law is given. But we have tried to answer all the questions that have come out in the public, in our annexure 2, in our understanding of the bill, and we invite the committee, if you think that there is anything that's not clear, to clarify it. So, Chairperson and honorable members, the Protection of Sovereignty Bill does not prohibit foreign funding or cross-border transfer of money, but rather intends to regulate foreign funding in order to safeguard Uganda's sovereignty. Uganda is not the first to enact such legislation. Uganda has found it necessary to safeguard its sovereignty, security, values, and norms that we hold sacred as a nation. The Honorable Chair and members, these are the proposals contained in the Protection of Sovereignty Bill, which is before you for consideration. We beg to submit, and we call upon the committee and all the people of Uganda to support government in this quest, and where there is any clarification that needs to be made, we are happy to make it. If there is anything that's not clear in the bill, at least so long as the purpose is clear, we can work together to correct it and make a bill that works for Uganda. I thank you.
Thank you. Thank you, the learned.
Chair, only one question. There's a recurring theme throughout the bill, and that theme is foreign interests.
Foreign interests.
Yeah.
Yes.
Could the Attorney General consider defining foreign interests?
Yes.
So for purposes of clarity.
Yes.
Thank you.
Thank you, Honorable Oluwayo. Honorable Okeyo.
Thank you, Chair, and the Attorney General for the presentation. Honorable Chair, I will begin with the title of the bill. Is this the best title of the bill? National Sovereignty
Well,
Bill.
if they came up with the worst, we can give them the best.
I want elaboration on that. Then secondly, Honorable Chair, there are laws, for example, the NGO. What really is not addressed by the Penal Code Act, what is not addressed by the NGO Act, that actually this law is trying to address. Because when you see all these laws we are citing really have that clause. That it brings me to, apart from humbly using the word foreign agent, I would alternatively use the word spy. I want an explanation from the Attorney General.
Thank you. Honorable David Livingstone.
Yeah, I would seek clarity from Honorable Attorney General with regard to a particular kind of recipients of funding from abroad, but where those people, where the recipients don't necessarily have a contractual relationship with the sources of funding. For example, you have Ugandans who run agencies locally. They may be NGOs or community-based organizations who are supported by people outside of Uganda, where the local recipients' causes resonate well with people in the diaspora, but where these local recipients are not necessarily agents of the sending individuals. For example, you have local churches which support orphans in their communities, and where a church in Russia or the United States or some country has a church member who finds this local community-based organization via whatever means and sends some money. But where cumulatively the money is coming in would fit within the ambit of the currency points that are prescribed here. So where if you run an audit, you would find that this CBO, goes through $1 billion shillings beyond the 400 currency points. How would you deal with that kind of scenario? Because it's a cause for anxiety in the population.
Thank you. Honorable Hajat Sauda.
Mr. Chairman, I would like to appreciate the Attorney General for the courage that he has. Given the level this bill has put Ugandans, if Attorney General was not courageous enough, by now he wouldn't appear before the committee. Attorney General, I would like to appreciate you for that. Mr. Chairman, first of all, I would like to find out from the Attorney General. You recall the Right Honorable Speaker directed that this current Parliament is running out of time. And she advised that other bills should be withdrawn. And many members who had private members' bill, government bill, were withdrawn, awaiting the next Parliament. And given the time of this bill, I would like to find out from the Attorney General, why are you introducing this bill at this material time, when we are left with a few days to end the term of this Parliament? And why is this bill so much in a hurry? Aware that in the order paper today, you are supposed to present on the floor of Parliament today, in which Parliament is sitting right now. We are on the order paper. It means we are left with few hours for you as the chairman to present this bill on the floor of Parliament. Attorney General, why are we in so much hurry with this bill? And what is so special with this bill? I would like you to answer. And two, Right Honorable Speaker, Right Honorable Chair, sorry, Right Honorable Chair, aware that this bill creates too much red tape. We have so many bureaucracy that if the person living outside this country or an NGOs or anybody supporting this country, there is too much bureaucracy. Don't you think that this bill would discourage our development partners? For example, we have people who are supporting Uganda, like FDI, aware that in 2024, FDI alone gave more than 2.8 billion in the economy of this country. In 2023, huge amount of money was given in this country. And look at the level of bureaucracy, the red tapes that we have in this bill. Don't you think most of the development partners, the NGOs, would get discouraged and run away from this country? And finally, the Attorney General, look at the definition of this bill. You put it clearly that the definition of the foreigners is anybody living outside Uganda and any Ugandan who is living outside Uganda. In fact, you are defining that anybody who is not within Uganda is a foreigner. Aware that we have the issues of dual citizenship. You didn't put that in your mind. And anybody, the moment you left Uganda today, the moment you cross to Kenya, other country, you are now a foreigner. Don't you think this bill is quite dangerous for our people? And the Attorney General, my final submission and advice is, this is not the right time to introduce this bill. And when we are introducing the law should look at Ugandans as a whole. The moment we think of introducing the law that targets few individuals or few organizations, we are bound to mess up this country forever. To me, this bill is being brought up in a bad faith. You are targeting just few individuals who are getting support out of Uganda, which is very dangerous. You are only looking at politics. You are not looking at the economy of this country. I advised that you put at the lenses, you look at the economy. How much support and how much money is coming from outside. Aware that we are among the poorest nation. We are depending on foreign money. As a country, we have nothing completely. All our money depends on the foreign money. And now you are trying to restrict, to control, which may disorganize this economy. Otherwise, thank you, Mr. Chairman. I still have many to put across, but I will bring in one by one.
Thank you, Honorable Lanya. Some questions actually are not for the Attorney General. First, and Parliament is in session. So don't worry, Dr. Gilbert Olanya. We are doing this. We are following due process. So, Honorable Segona of Busiro.
Mr. Chairman, even when it takes you long to remember.
No, the constituency.
Thank you very much. I do not want to join Honorable Gilbert Olanya in thanking the Attorney General for the courage. At another occasion, I will know how to deal with him. One, Mr. Chairman, if you look at the definition of a foreigner does not mean, but it includes. In my little memory of legislative drafting, when somebody says includes, the definition is so wide that it can incorporate and keep bringing in anybody, and that it will depend on who chooses to enforce the law to bring you into that bracket, as long as they use the word includes. So I wish the draftsman would be clearer to say it means the following people. I have already opined that probably you need to, even when it is ugly, Honorable Chirewa Chwanuka, you can quote it by removing the use of that word foreigner and criminalize activity as opposed to the profiling of the word foreigner. I know you're always blunt, that's why you said you do not want to move in circles. But having been here longer than you, it is my advice that in legislation, that's what we do. The other thing, Mr. Chairman, is the definition of foreign interest is not there. When you do the collection for the Attorney General who does not want to meander, when you read the entire bill, you may get a glimpse of what foreign interests they are talking about. But for purposes of criminalizing, there is no definition of what amounts to foreign interest within the, if you read clause 1 and 5 together, which criminalizes. Now, with respect to, and I want to thank, I think the honorable folks, you said Owolweyo. I want to add to the question that he put across when he asked about foreign interest, but also the word sovereignty. You're talking about the protection of sovereignty bill. You also direct Ugandans to protect or promote, I think in clause 5, but you do not tell them in clause 5(3), a person shall not engage in any activity that promotes the interests of a foreigner against interests of Uganda. Now, when you leave ambiguity, you are literally making everybody a potential criminal. Because I don't know, I may not know the interests of those foreigners you're talking about. Supposing their interests rhyme with mine, you're talking about promoting democracy, rule of land, constitutionalism in this country. We may have shared values because this is a global village. So tell me, just be blunt, be audacious and shameless, put across what you want us to do. As subdued Ugandans, we shall oblige. But please do not make them ambiguous to make all of us potentially criminal. Then the activities again, in clause 5(4), clause 5, yes, 4. Again, be clear on which activities you're prohibiting. You don't simply say engage in any activity that promotes the interests of a foreigner. Then you say the person who promotes the interests of a foreigner against the interests of Ugandans commits an offense and is liable, blah, blah. The next comment I have relates to this business of seeking permission from the Minister of Internal Affairs. It has legal, political, and economic ramifications. For the benefit of these young brothers of mine, the ministers who were not there during the days of Idi Amin, even when you sold your land to go and seek treatment abroad, you would go and line up in the minister's office to be permitted to buy foreign exchange. Some people died because the minister would take long to authorize or refuse. In other cases, the minister refused. And when the minister refused, you had no recourse. Today, you can say you have recourse. You can go to a court of law where the Attorney General and I are participants, and you know the kind of backlog you have. By the time you get clearance from General Muhoozi here, I don't know how much economic interest of Uganda you would have had. I want to implore them painfully because they seem to be hell-bent on having the law go through. Why don't you simply legislate on a reporting requirement? We declare. I would have no problem with the word declaring. But if I must seek permission from the minister, assuming I'm a practicing lawyer, someone has paid me 500 million, then for me to require more payment, then I go to the minister. Secondly, I think Honorable Kauma from Miganga mentioned this, the promotion of corruption. Some people are doing business with foreigners. Business, some of which may involve exports of commodities, others services. Then for me to be able to get money, I must go and seek permission from the minister. There is a problem with that. The other question or comment, normally when you are making a legislation that has penal provisions, you also provide for defenses available. When you do not provide for defenses, you make it a strict liability offense for the individual. I don't know whether it is the intention of the Attorney General to make this law a strict liability offense. And of course, I have problems with telling somebody, you go register with the minister or register as a foreign agent. Really, have you taken us to those levels? Or do you see people going to register as agents of foreign interests? I don't see that happening. Then finally, what is government policy? Because we used to say, just write not a booklet, but give us a volume like you give us in your policy framework, so that we know what your policy is all about, and we know how to walk the red thin thread. And then why don't you just be bold enough to declare which countries are hostile, so that we don't deal with them? Previously, I remember in some election where you declared Rwanda a hostile state. I don't know if you have since removed it from the list. Just publish those countries that you consider hostile, so that Ugandans avoid dealing with them, to avoid problems with you for as long as you are still around. There is this thing, this law called the Money Laundering Act, under which I think FIA, the Financial Intelligence Authority, and then the intelligence services have proceeded to block accounts of most of these NGOs, even without going to court. That law is in existence. Why wouldn't the Minister of Internal Affairs simply consider amending that? If you just want to monitor and provide sanctions without causing us these problems of having to fight. For me, as a person who fights to promote national interest and the policy, even when I do not know it, I find it very difficult to defend this law with the clauses and even the name. So tell us, what is sovereignty? Which sovereignty you want us to enforce? Because you have made it a crime for me not to promote and protect the sovereignty as in the minds. Very, very finally, just to remind the Attorney General that there is a decision in this country of the Supreme Court that even when I tell a lie about and against the government, I may not have been patriotic, but I don't commit an offense. So are you not empowering whoever will be enforcing this law to use discretion, including arbitrary discretion, and criminalizing all Ugandans by making literally every activity across the borders presumably a criminal activity? I thank you.
Very important. I actually thought you would also highlight, you touched on it, as a practicing advocate, representing interests of those who come to invest here. You deal with them on a daily basis. You now will be required to register, to get certification. Yes. Yes, ordinarily you are going through what actually you go through to get a certificate from law council, now to get it from minister in charge of internal affairs. And of course, you are an agent of foreign interests, Medad Rubega. By no, I thought you'd highlight that. Very important. So, and that is clause 14, 15, 16, 17, with regards to practicing advocates. I know law counsel, when they appear, they'll have to talk about it. But thank you. The learned Attorney General and the Minister are ready to respond. Honorable Kahonda, then I come to you, Honorable Museveni. Yes.
Thank you, Chair. Someone raised this issue, but I want to add my voice to it on the definition of a foreigner. When you look at A is a non-Ugandan citizen, B, a Ugandan citizen residing outside Uganda. Attorney General and the Minister, can you elaborate more on this? What qualifies a Ugandan to be declared a non-Ugandan? Is it by simply traveling outside the country? Does it qualify that person to be a foreigner? And if not, what activities should one be involved in to be regarded as a foreigner? And then two, an international or multinational organization. We're aware that we have multinational companies, the MTNs, the banks, that are carrying out activities here in Uganda. And this has effect on both economic and job creation. Many Ugandans are working for those multinational organizations, and they are earning a living there. We are earning foreign exchange through taxes and any other. What is the effect of this bill to this? Thirdly, Mr. Chairman, on F, the bill goes ahead to say that a foreigner is any person, institution, or body that the minister may, by statutory instrument, declare to be a foreigner. To me, here it's as if we are giving the minister excessive powers. Any other day, General Tafire can develop a quarrel with Kahonda, and he declares Kahonda a foreigner. We should be clear on this. That is giving a minister excessive powers.
Mission on experience or?
No, I'm just giving it as an example. And lastly, Mr. Chairman, let's also discuss this in relation to jobs and on the economic part of it. This bill automatically will affect the funders from getting involved in some of the activities, because the activities, most of them, are not clearly defined, apart from the fighting against the national policy and the interests. So when you look at some of these countries that the Attorney General has highlighted, first look at the countries that have passed such a laws that the Minister of Internal Affairs has presented: United States of America, Australia, France, United Kingdom, European Union, India. Then Attorney General has gone ahead to add China, Russia. The interests are different from ours. For them, they don't need aid. Look at our budget. What ratio?
I thought the Attorney General clarified that aid or any other funding is not part of this scope.
But you see, the objectives, the bill talks about the aid, especially this one that comes to government. They are now qualifying government not to be an agent, not to register. But they want someone who is dealing with them to register. That means they want monopoly.
They are not stopping you from getting money from, but they want you to declare, register and declare. Get permission. They get permission.
Mr. Chairman, we are talking, the money we are talking about is about 5 trillion that comes to our national budget. And the jobs we are talking about is about between 20,000 to 50,000. These are Ugandans being employed by these multinational organizations. And the qualification for registration, by the way, to renew the registration, the certificate, will be issued for 2 years. It expires. And we have organizations that have been employing Ugandans on a contract of about 5 years. That means they will no longer be qualifying to get the contract for 5 years.
If they don't renew.
If they don't renew. Of course, that is the effect. So, Mr. Attorney General, I just wanted you to give more light on those issues I have raised regarding the proposals. Thank you.
Thank you. Honorable, our own Museveni now. Honorable.
But
to
make our work easy.
Yes.
I think there should be, before we tackle this bill, if there was like an audit report of our existing laws, there would be no requirement for this bill.
With regard to?
Because if you look to the laws, there's nothing new we need to tackle than amending the existing laws. Because this law has caused a lot of noise in the community, not only in Uganda, but even outside the country. It makes the law look awkward, as if there's a hidden agenda. And if we talk about the selective activities, which examples do you give here to convince me when I'm here to know that this law is good, really I should support? And if we have Money Laundering Act, we have the NGO and others. If they are tackling the same problem, why can't we amend and we combat what you intend to bring in this bill?
Information, Mr. Museveni. Can I give you information?
No,
information allowed.
Pardon?
Is Honorable Museveni.
Thank you. Yes, Honorable Yoweri Museveni.
Excuse me.
Thank you. Mr. Chairman, I would like to inform Honorable Yoweri. As I stated earlier, this law is targeting very few individuals. And looking at the other paper now, you clarified.
Yes.
It means by this week or next week, the law will be passed. Aware that one of the opposition leaders now is out of the country, and government assumes that the opposition leaders who is out of the country may come back immediately and he may lobby huge amount of money. And what the government is fighting for, by the time Bobi Wine arrives to Uganda, the law should be in place. So you are targeting very few individuals, which is very wrong.
Honorable
That's the information I
Anya,
want to give.
you were given permission to inform, but
I'm leaving it to all of us.
Okay, okay.
So, Chair, with the definition of a foreigner, where a Ugandan is declared a foreigner, I see it like this law is inconsistent with our constitution. If the constitution is saying otherwise and you are saying this, then it looks here we should be smart to tally it with the provisions of the constitution. Thank you.
Honorable colleagues, you have a chance. This is just a proposal. It's before you. So,
which the minister and
the annex to the presentation of the learned Attorney General, right?
when you look at the countries, Honorable Attorney General, Kazakhstan, Kyrgyzstan, Georgia, Russia, China, Hungary. These are countries which are well known to be autocratic. And specifically, when you look at the laws which were passed.
Honorable, you gave us a list of about 14.
Yes. The rest.
Are you saying all of them?
The rest, they are in two folds.
Or you?
Those ones which I have
mentioned. You are being strategically selective.
Those which I have mentioned.
Yes.
They are autocratic countries, well known everywhere, even in Uganda here. The rest, like France, United Kingdom, USA, these are economically well. They have done to their best and they have uplifted themselves. They need they less need the support from outside. Specifically, when you look at the law of foreign agent law in Russia, it was specifically targeting engaging in political activity while under the influence of the foreigner. Specifically, it is targeting in that area. And when you look at the law in Georgia, it was targeting the NGOs and the media. And in Hungary, foreign-funded NGOs, media and researchers. Kyrgyzstan, that one. NGOs receiving any foreign funding. They are specific. On this, Honorable Chair, I don't know why the Minister and the Attorney General, they have felt short to show us where on the continent called Africa, no country has been listed. I expected you to list Zimbabwe, because this law is there, and you know whom it is targeting. And to the list, even Rwanda. They have tried it, but for them, they are actually encouraging the foreigners to come and bring money according to their law. My colleagues have talked about the issue to do with the foreigners. I will not, the definition to do with the foreigner and the foreign agents. But my reservation specifically is on the issue where they are criminalizing the professional service, the professional services under Clause 4, under the agents of the foreigners. This will go a long way to do with accountants, engineers, lawyers, whoever is linked in any way or working for foreigners. I'm of the view that we should look deeply to safeguard our lawyers, our accountants, our professionals working for those big companies. And lastly, on the do we envisage a situation where many people are working, for example, for MTN here? Many people are working for a foreign bank like Equity Bank. These are foreign banks. KCB. By that definition of agents of the foreigner, What about our people who go and do cross-cut and they go and they study from Dar es Salaam or anywhere in Africa where you do the exchange of the students? I think, Honorable Attorney General, we need to revisit that definition if we are to come up with a better law, not even closer to that one of Russia or Kazakhstan or China or North Korea. Because for them, they were specifically targeting to curb down the agencies and the cultures. For example, this one to do with the, where we made our law to do with the sodomy in anti-homosexual bill. It is only the name which changed in Korea because they wanted to maintain their culture and they had to pass that law. Thank you.
Okay. Honorable Werike.
Thank you, Chair. I have General to help me. One is on the issue of foreigner. I'm looking at Kyagulanyi, who is outside this country now. Specifically, I want to be specific on because that's what he's saying. If now he sends money above 400 million, is he going to be regarded as a foreigner? Doesn't matter. But that's where we're heading. So what are you trying to cure? Eh? The second one is about the banks. I am aware that Bank of Uganda, each time you are getting money from any foreign person, whatever, they always seek for explanation where these funds are coming from, and you provide that evidence, even if it's more than 400. Is this not going to be a duplication, or for you to run it this way, go and look for the minister, then go and run to the bank? So where are we going to belong in that regard of banks clearance and the issue of Ministry of Internal Affairs? And beyond that, I see you here capping that anything beyond 400 million or whatever, you will always keep asking. A practice which I don't see any foreign institution doing it. I've shown you where I'm going to put my money. Why should I keep coming to you because you're saying this permission applies for a period of 12 months? I'm doing my project, whatever it will be, but the banks doesn't do such a practice. Why do we do this capping in this kind of line?
Let's break there and have the Attorney General give responses, because some of the responses he will give could be able to answer the questions that might come up. And
thank you.
I request the Attorney General to be as comprehensive as possible, such that you can even capture other areas you suspect.
About foreign interest, can refer you to clause 10. If it is not clear, we can clarify it. But we are happy to include a definition of foreign interest, but we thought that clause 10 was saying that any function with the aim of promoting foreign policy in Uganda, that has not been adopted as policy by cabinet, but we can define it. We can take it to clause 1 and define it better. Foreign agent being a spy, it could be a spy, it may not be a spy. I don't know. Honorable Keo.
May I seek clarification? Are there policies and activities that the cabinet has approved so that we could know? Because anything that has not been approved and adopted by cabinet would constitute an offense. So we need to know which ones are those that you have
Anything
adopted.
that has not been adopted by cabinet is not government policy.
So anything, if I act outside that, I'm breaking the law?
Yes.
So where are those that you have adopted?
Pardon?
Where are those that you have adopted in our gazette?
Honorable member, I think every year you receive a ministry policy statement from almost every ministry. If you look at that, it will normally tell you about the policies in that ministry. Those are normally adopted by cabinet.
Mr. Chairman, why I want the Attorney General to be clear. First of all, those are policy proposals. They bring them here. They are proposals to begin with. Secondly, are you telling Ugandans that they go get those books, read them, anything outside them is criminal?
Yes. You see, Honorable Segona, I think you should be the one answering that question instead of me, because you're the ones who receive the policy statements. These policy statements tell you what the policy of government is in that particular area.
That's correct.
Let me answer so you don't interrupt. Otherwise,
No, intervention is acceptable in parliamentary practice. And the reason I'm concerned is that we are making a law with the penal provisions and criminal ramifications. Is the Attorney General of this country telling Ugandans that anything outside those policy statements is going to constitute an offense because it's not approved by cabinet? Is that what you're saying?
yes. For a simple answer, for the public, yes. I am telling the public that policy is not thought in people's minds. Policies of government are recorded in policy statements and laws of that country. So you cannot imagine a policy which is not written anywhere. So that is the simple yes.
But I'm not a public player, I'm a private player. You only criminalize me for what I do against the law. Even policy is not law.
You see, Honorable Segono, we are writing a law.
Procedure.
So the moment we write the law, it becomes a law.
Anyway, I'll write my
procedure.
Yes.
I wonder if we are proceeding well, Honorable Chair, where a member is having exchanges with the Honorable Attorney General at random, which is really hampering the Honorable Attorney General's proceeding. Otherwise, I might behave in a similar manner and another member might, and we will not achieve much. With the highest of respect to my
Members,
land friend.
Let's give the Attorney General ample time to respond, because once we get it right,
to identify the gaps. For example, you will not find any single law in this country, in all the laws that you have mentioned, which says that if you promote a foreign policy in Uganda, it's wrong. There is no such law. So yes, you could say, amend the various laws. We took the policy direction of saying, no, let's write a standalone law. So we don't have any law that's dealing with this particular aspect. Honorable Zijan, yes, you actually raised an important question, and I want to spend some time on this because I think this is where the crux of the matter is. Honorable Zijan says you have a CSO in a particular place which is taking care of orphans. And that aspect resonates well with a foreign funder. Now we are saying, does that person need to register? My simple answer is a no, because it is part of our policy statement. It's part of our constitutional requirement to take care of the indigent and the orphans and etc. So if the NGO or the CSO, its business is taking care of orphans, that is a policy of Uganda, and that one can be supported by anyone. So that's not an agent of a foreigner. So, and I think that's why it's important for us to look at clause 2.2. Now, and I think what we are saying here is that all the CSOs can do whatever they want to do, but what they must be doing is supporting a policy that exists in the country. And therefore, it is incumbent upon us to consistently and openly, for example, take out the National Development Plan. That sets out the policy of government, sets out the plan of government, talks about all the things that government wants to do. And therefore, if you have a CSO which is plugging into that, that's not an agent of a foreigner. Even if in another foreign country there is a requirement, rather a policy to take care of orphans, it is not a foreign policy because it is already our policy. So what I'm saying, once the cause is aligned with government policy and government plan and is getting funding for that, that person is not an agent of a foreigner and does not need to get any registration. Honorable Sauda, yes, there could be corruption.
Mr. Chairman, let me get clarification on that. That point you mentioned is very important. You stated clearly that so long as it aligns with our policy, and one of the policies of Uganda is promotion, lobbying for funds to contest as the president of this country, let me hope I am not supposed to register, because it is our policy to promote democracy.
Yes, but clause 2.2 has told you in the promotion of your democracy, you should get the promotion of the democracy. Yes, you can get some support from outside, but much of the support should come from Uganda. So, promote democracy.
This time I'll help the Attorney General. Actually, the answer lies in 2.2a. If what you're going to promote is engaging in political activities in Uganda, for or in the interest of a foreigner, you go to General Tafiri for permission.
Yes.
A quick one, Honorable Chair. Actually, in line to what Honorable Zijan stated, I wanted the Attorney General to be clear. Faith-based organization. I remember when we were making the NGO amendment, we were very clear. Where does it leave the faith-based organizations?
Thank you, Honorable Keyo. That's
are
exactly
they catered
what,
for? Are they not covered in the law?
So,
and that's
we'll leave that to the committee. If you think it is okay for faith-based organizations to participate in politics in the interest of foreigners, the committee has the power to allow them. Because you see, this act is talking about specific activities which are not for faith-based organizations. But if the committee thinks that is perfectly fine for a faith-based organization to participate in politics in the interest of a foreigner, we can exempt them. No, what I'm saying is that these faith-based organizations are already exempt from this law because for them they don't participate in politics. They don't solicit money for the benefit of the foreigners. If they do, well, what we are saying here is, for me, the faith-based organization that I know doesn't do it. So, pardon?
I'm asking whether, I think now you've clarified that this is purely political.
It is political, social.
If the faith-based organizations are going to solicit for funds in the interest of foreigners, then they can. If the politicians are, then they cannot. Is that
no,
what you're saying?
what we are telling you is that the law as it is written now, even faith-based organizations should not solicit for funds for purposes of supporting a foreign policy here. But I'm saying, if the committee thinks that it is prudent to exclude the faith-based organizations, then they may be able to do so. But for us, the way we've written it, we have said, no, if it is a foreign interest, none of us Ugandans should participate in it, whether faith-based company, whatever, don't do it. While you're introducing the bill now, I'll leave that to the chairperson of the committee because, Honorable Lanya, I am here by invitation of the committee. And as I had been advising, I have many things that
we invited you because you sent us a bill.
Yes. So for me, I sent the bill.
Asking why did you send it now?
Like I have so many other bills on the order paper today. Our business didn't stop. This is part of our business. Now, the issue of FDI, colleagues, let us not, and I'm going to say this in a way which I'm looking for the best way to put it across. Uganda is poor. Uganda needs aid. Uganda must get aid in order for it to survive. And therefore, we must take aid, whatever the consequences are. Committee colleagues, we need to be careful. We must not receive money for whatever money we need because we are poor. Therefore, we get money to corrupt our morals, determine our destiny. That's what we are saying here. We are not saying we don't want FDI. We are saying let it come. We want foreign direct investment. And it has been coming. But we are saying if it is coming for these purposes in clause 2.2, if it is coming for the purposes of clause 2.2, please don't bring it. Colleagues, Uganda does not need the money at any cost. There must be a point, I was sharing here, if we were allowed to speak vernacular, there were vernacular ways of expressing what you need to do at any cost, that you can get anything at any cost. You may end up selling more than you can give. So yes, this law is not for purposes of stopping FDI. In fact, if there is, pardon? No. I think that's, it may be misunderstood. But what I'm saying is that this law is not about, in fact, if this law has, in your view, the consequence of stopping aid, then we need to rethink it. But if it has the consequence of allowing, if it has the consequence of stopping unwanted aid, then you may want to think about it. So what we are saying here, you need to strike a very neat balance between growth and your security. For example, if we say it's okay for people to recruit, enter into partnership and recruit people, like we say in D, recruit people to promote the interests of a foreigner. For example, we have not had a war here. We've not had a rebel group which has not been supported externally. If we are saying it's okay for us to allow people to recruit for the interests of a foreigner, then that's what the parliament and what we think, but we can find common consensus as a country and say, we are happy to live with it, let's go on with it. So this law is saying, no, if you want to recruit for purposes of supporting a foreign interest, please don't bring it here. That's what the law is saying. So it is...
Chair and Attorney General, could that resonate?
What's that? Which point is that? Are you raising on a specific point or just interjection?
On the same, and I'm seeking clarity. With the fact that we do not go blanket and say anyone receiving more than this money should first get authorization from the minister, and then look at specific persons or characters who are prohibited from receiving any money for, and not make it blanket. Like for someone who is an architect working with a Saudi company, working with a UAE company, who's just doing an ordinary day-to-day job and is earning over and above this much. If the intention is not to curtail anything and everyone.
Okay, I'll go to, I think that question was raised and I think you're repeating it, and let me get to it. I think this was Honorable Kahonda raised this.
Of activity that we do.
Honorable Lanya, the Attorney General firmly said, if it is in the interest of the committee to define, it is your responsibility.
Yes,
so
Mr. Chairman, that's what I'm saying.
It has been given to you.
Mr. Chairman, you wait first. His explanation is dwelling majorly everything was referred on foreign interest. Aware that we are dwelling majorly on foreign interest. For example, the World AIDS Organization, we have the foreign interest of stopping the spread of HIV by 2031. We have the foreign interest in promoting quality education.
So what is your point?
All our interests are foreign. So that's why I'm saying we need to define foreign interests well. And finally, Mr. Attorney General, finally, let me finish.
Many of the things you're saying were actually asked, and if you allowed me to finish,
to conclude, it would be much better.
I would like to get the clarification from you. Aware that Netherlands government sponsored iPod heavily and massively. I would like you also to clarify on that, whether that was interference. Thank you.
Thank you. Honorable Attorney General, please conclude.
With your politics compared to how we proceed with others. Why? Because he's our legal interpreter as well. That's number one. And number two, by occupation, this is his bill. And there are some technical inputs that we would need from him before he disappears.
Before he takes leave, he won't disappear.
He might disappear from the committee room, and we're going to go into the writing, to retreat into writing.
Let's give him a chance.
I am only asking, in clause 2D, 2D, or throughout the bill, would it not help if we simply clarified that we are prohibiting in activities that are adverse to the interests of the country, other than using blanketly the word foreign foreign, as if everything foreign is bad. And then I think when he gets to answering my questions, he will answer on where the interests are mutual, because they could be foreign interests and Ugandan interests as well. But why don't we include the word adverse?
The word adverse. Okay, and the technical people are capturing. Honorable.
That we write down supplementary
Yes.
questions.
Yes.
And you avail us the opportunity to ask the Attorney General.
Brilliant
after he has
idea.
Concluded his
Yes.
submission.
Okay, supplementary questions should be scribbled down, and the Attorney General will be given a chance. I will summon him here.
Or other assistance from a foreigner, whether in cash or in kind, in excess of 20 currency points.
Yeah, so even when I am not using, because this one now is divorced from two.
Yes.
Even when it's not for purposes of two, so I have no right to solicit except with the approval.
Yes, so if you're soliciting for money from a foreigner, that's what the provision is saying. If you're soliciting for foreign support, past 400 million, get permission, get approval.
No, his point is transaction and what if he actually goes on so that you don't curtail transaction, but he must declare.
Well, I think...
So that business doesn't come to stand still for purposes of seeking permission.
This law...
The exception should be for those who are under application.
But 22 is not under 22.
Okay.
Now 22 is bringing in others
22
outside
is not only
provision
foreigner or
two.
agent, any
no.
person.
No, Commissioner, if that is the clarification you went for purposes of 22, that we can do.
That we can.
Because this act, you see, and I think for me it's a drafting thing, because the application of this act, the application of this act in section 2, everything you read in this act should be read to apply to only this. Because this is the application question. So you cannot talk about anything else other than this act only applies to this. So this is the application. So you can clarify it and make it better English and repeat it and say, as stated as per the application of the law. But you see, this act applies to a person who is an agent of a foreigner. This act. So don't ask me, who has no dealings with a foreigner, under this act. I have no business.
Exactly. Now 22 is saying a person or an agent of a
So
foreigner.
a person still, even the person,
yes.
even the
a
person,
as long as he's doing activities under 22.
under 22, this it does not relate to my grandmother in the village who has no dealings with a foreigner. You cannot come.
So your grandmother can solicit from a foreigner.
My grandmother can solicit from a foreigner so long as they are not
He's
dealing
not doing activities
under
under
22.
Okay. I think it's... Thank you. Go on. Are you concluding?
No, the minister's powers, because you see, if you say that you should allow people to receive $1 billion, I don't know, I'm looking for words to use in English, but I can't find them. But I may be more expressive in Uganda. In Uganda, we're saying, you know, you're saying that you may try to cover yourself. Okay, having spent the whole night uncovered, at about 6 in the morning, you cover yourself. You have not served any useful purpose. So if you allow all the money to be spent, and then the problem has already been done.
Attorney General,
So reporting tomorrow.
The current practice is even when I'm receiving $200 currently, the bank will require me to declare the purpose
source.
and the source. So the question we are saying, or the issue we are raising is, supposing people, you do not restrict, because first of all, at the level of soliciting,
But I've answered the question, Honorable Segona. I've told you my understanding of it. You have said you'd rather let people receive until whatever amount, and they report after.
Actually,
So we are saying, if they are receiving money for purpose of recruiting a rebel outfit,
then they declare after.
Then they declare after the rebel outfit has been recruited. Well,
fait accompli.
so we are saying that the declaration after may,
No. Actually, contrary to what you think, and by the way, it's me, I would rather have the dev I have than bringing a new angel, as long as I'm going to be destabilized. But the point we're making is at the level of receiving the money, the current practice, even without law, but I think now there is law, being the Anti-Money Laundering Act, which requires the banks, before they even allow this money onto my account, I'm required to explain
Declare
and
source.
even prove, declare the source. And someone has been bounced back, which I also find outrageous. If it has come, why do we bounce it back? Let the government take over, take the money. But my question is, one, delaying transactions. Two, is where the minister does not even have timelines.
That is now a function of law. We can now put, if you have asked for permission from the minister, how
Meaning that what I'm doing is illegal until the minister says it's not.
yes, Honorable
Chair.
General, a moment, then I get you.
To add something on what Honorable Seguna was
Okay.
stating.
Okay.
Honorable Chair, actually you have said we can cap the period.
Yes.
But I also wanted to know, appeal system.
It can never
If
be
the
forever.
minister is delaying and whatever, don't I have a system where I can appeal, maybe High Court, maybe Chief Magistrate's
That
Court?
is it. Again, that is within your powers. Honorable Mohozi.
Where a Chibanja holder goes to the landlord, requests for permission to sell his interest, made provision for 6 months, then they said the permission shall not be unreasonably withheld, and so on and so forth. Just look at a practical situation where somebody wants to make a transaction, the minister takes ages to provide a response. That's number one. And for me, I know that what I'm doing is lawful. But let's even assume the money is for a political activity, and I want the minister to approve. As Honorable Kahonda said, Kahonda is asking for permission from General Tafile to conduct lawful political activity. But the person seated in that office deems it unlawful. I am coming from a background where we had our peaceful demonstrations. We formed a 4GC, for God and my country. The minister declares it, what do you call it? A terrorist organization or association. Then you go through that process. The person says, no, whatever you're going to do is illegal because you are so and so. You know, who simply refuses to act. I think let me be particular. Maybe you will understand this better. We have a colleague in town who wrote an article in the Monitor and said that his mother went to the Minister of Finance back then to request for permission to buy foreign exchange, take her husband for cancer treatment out of this country. She went there 3 times and she would be told the minister is not in good mood. The 4th time, she enters, the minister got the papers and tore them, threw them in a dustbin without looking at them. I want to avoid creating a minister of that kind. Why do you insist?
What's your proposal?
My proposal is, first, let the money come. It will not be released because the practice is they will not allow it into your account. They will
Banks
not allow
will
it.
not release.
They will not. We can make a law to that effect. That's number one. Number two, we must also cap the minister's power and exercise of discretion. Within how long?
Yes,
Number
that's
three,
now what we is.
when you're talking about solicitation, at the time of solicitation, I actually do not know whether I will get this money. Because NGOs in this country write proposals. You're simply writing a proposal. You're now telling an NGO that it cannot even write a proposal. You understand? Because the determination of what will be foreign interest will be a decision of one person who is enforcing the law. Did you write this? In my interpretation, this was promoting a foreign interest. Anyway, I wanted to throw this to the Attorney General from a technical angle before we write our report. Tell us what he thinks about those views, because for me, I am I mean, I don't know, I'm persuaded to think that you're bringing this law in bad faith. Convince me that you're acting in good faith, and then I'll give you a good law.
No, I think for me, Honorable Chair, I've told you what I think. You may not have
Giving you support to iPod.
Clause 2.2. Clause 2.2. Was iPod giving us money, engaging in political activities for the interest of that foreign country? If so, that is a problem. But I don't think so, because they were doing it for the interest of our country.
Answered.
Thank you.
Okay, honorable colleagues, I think we allowed the learned